Hearty welcome to another edition of the program Familiarise with the Law, coming to you from Star Television. Channel 21, where we broadcast live from our Media One Center, Premium Street, Brookfields in Freetown. You'll have the opportunity as viewer to reach us in the city of Bo and also the city of Makeni as we move along with the program. My name is Abdul, Rahman, Kamara. My studio guest is lawyer Adrian Fisher. Fisher, welcome to the program.
Good afternoon, Rahman.
Today we're going to look at very critical issues. First off, we're going to examine the need for the urgent expedition of the 1991 constitutional process that has reached a stage for which everybody seems to be appreciating now. We're going to look at the way lawyers are conducting themselves when it borders around their political leanings. We shall also be looking at a very critical element that borders around the aspect of the roles and responsibilities of the clerk of parliament and that of the speaker of parliament. And a 4-day visit of the ECOWAS body concludes yesterday. They came out with a position paper where they urge the judiciary to expedite fairly, independently cases that are before them, especially those that related to petition. All of those things we're going to actually look at. And we shall take our time off to talk a little bit about the nominees. As we have here with me a press release from the Office of the President, where ministers has been nominated subject to approval of Parliament where necessary. All of these we're going to actually touch on. But for the benefit of hindsight, what I will do, I will take my time off to go through the press release from the Office of the President, having announced the following appointments subject to approval of Parliament. Ministers. Chief Minister, Professor David J. Francis. Minister of Foreign Affairs and International Cooperation, Dr. Ali Kabar. Minister of Planning and Economic Development, Mrs. Nabila F. Tunis, Ni Kuruma. Minister of Technical and Higher Education, Professor Iya Bakima. Minister of Works and Public Assets, Mr. Raymond Anes Denison de Souza George. Minister of Trade and Industry, Mr. Peter Bayoko Conte. Minister of Transport and Aviation, Mr. Kabine M. Kalon. Minister of Mines and Mineral Resources, Professor Maureen Manye. Minister of Lands, Housing and Environment, Dr. Dennis Sandi. Minister of Agriculture and Forestry, Mr. Joseph J. Danema. Minister of Youth Affairs, Mohamed Bangura. Minister of Local Government and Rural Development, Mr. Anthony Y. Brewer. Minister of Tourism and Culture, Mrs. Memunatu B. Pratt. Minister of Political and Public Affairs, Ambassador Foli Yumkela. Minister of Sports, Mr. Ibrahim Yelenke. Resident Ministers. Resident Minister South, Mr. Mohammed K. Ali. Resident Minister East, Mr. Andrew Fatoma. Resident Minister North, Mr. Abu Kuruma. Resident Minister Northwest, Haja Aisata Abdullah Kamara. Other appointments will be announced in due course. State House, Tower Hill, Freetown, 30th April 2018. These are the nominees from the Office of the President that are to hold ministerial positions subject to parliamentary approval. What's your take on the balance, regional balance in terms of the appointments?
Well, I think the starting point is this is Sierra Leone. Many of those people that you've just mentioned, you know, from the sound of their names, they may well come from one or other of the regions. But notwithstanding, many of these people are in fact linked with other regions as well. So I've always been one that say it is wrong to look at people based upon what regions they may or may not have hailed from. The fact of the matter is they are Sierra Leoneans, and I am yet to see anyone whose name is on that list whose competence I have an issue with. I think the time has come for Sierra Leone to move forward in terms of looking at individuals in relation to their competence and how effective they can handle the assignments given to them by the president, rather than to be looking at people to say, well, oh, he is from the north, he is from the south. I think Sierra Leone has to move on from there, because if we don't, we're not going to make progress if we continue looking at appointments or looking for who to appoint based upon which region they may or may not have hailed from. Yes, I understand that there is a need for national cohesion, but notwithstanding, our first preference should be for competence. And that is what I think from the list that I've seen. As I said, I'm yet to see anybody whose competence would cause me concern.
On the aspect of gender balance,
again, that is another issue. I mean, there are women that have been appointed in that cabinet who are very competent women. I mean, Mrs. Nabila Tunis, for example, very competent person. You know, again, this is something that Sierra Leone needs to move on from. We're not going to have a situation where we're going to have 50 men and 50 women in every appointment that we make, because there are a lot of issues that effectively mean that women cannot effectively compete with men as one would expect, or one might rightly want to see happen in our country. Even in other established democracies like the US, the UK, women are underrepresented in politics. So it is not new insofar as Sierra Leone is concerned. The important thing for me is that Sierra Leone needs to ensure that we have a level playing field. In other words, there is no glass ceiling through which women cannot climb. If we do that, then of course, regardless of whether we have 10% of women in any cabinet or we have 20% of women, what we can be assured of is that those women that climb that glass ceiling would be the competent ones that can go forward. Likewise for the men, if we have a situation where we have 70% of women that are more competent, then I would want to see 70% of women go forward. So it's a question of balance. And I think the fundamental issue for Sierra Leoneans right now is we need to make sure our institutions create a level playing field. So every woman is entitled to put themselves forward. But once they've put themselves forward, the key criteria should be one of competence.
Perhaps the mistaken impression is about the commitment by the political leadership of various political parties on ensuring a nearly equal representation, what we refer to as the quota for women, specifically women representation. This much talked about 30%. And for others, they may think all the appointments, but principally they would have loved to see a situation where women will occupy ministerial positions, forgetting the fact that there are other areas to serve. Judging from what you've just highlighted here, it behooves everybody to understand that it's about one competent stroke service delivery. Is that the case?
Absolutely. That for me should be the sole criteria, provided a level playing field is set. I mean, I for one, if I have a situation where, yes, I'm competing for a position with a female candidate, if that female candidate is more competent than me and can do the job better than me, I'm happy to let that candidate go. We should move away from this question of, well, it should be only 30% of women or it should be at least 40% of. We're not going to achieve that. Because the reality of the situation is that women have only been gradually coming forward insofar as politics is concerned over the last few years. It's not been that long. And again, I make the point of the man, when we go back to countries like the US, they've been in democracy for hundreds of years. Britain has been in democracy for hundreds of years. How many women do we see in their cabinet? Do they have a 30% provision for women in their cabinet? No. But the important factor is that they have laws that will ensure that women are not disadvantaged in selection. And this is where one of the things that I, for example, would be promoting is the concept of an Equality Act. An Equality Act would effectively ensure that nobody would be discriminated against on the grounds of their race or on their sex or on their political opinion, etc., etc., etc. So if we have that, then it means that whatever criteria applies to a man for a particular position, the same criteria would apply to a woman. So level playing field, that's all we need. We don't need no 20% or 30% or 40% quota, because when you do that, what happens if you put it into law and then you don't get 30% of competent women? Do you put square pegs in round holes? So those who are making this kind of assertions need to sit and think. And I'm happy that those who draft our laws are wise people that sit down and consider issues such as these. That if we put something like this into our laws and then we do not get the required number, does that mean we do not comply with the law? Does that mean that we just simply, as a matter of tokenism, put in members just to fill in that gap? And then we're going to have the same problems wherein service delivery, as you've pointed out, becomes weak and ineffective simply because we want to achieve a 30% quota. Does that take Sierra Leone forward? No, in my view, it doesn't.
So in sum, the names of nominees so far impresses you most?
Well, yes. I mean, I wouldn't want to pick out individuals, but I mean, all of them that I know are competent people. Mm-hmm. Those that I do not know personally, I've heard about them. You know, I'm aware of the work that some of them have done in the past. And again, I hold the view that they are equally competent.
A name that has stand tall ever since this release was out was no less a person, Dr. Ali Kabar, in the capacity as foreign minister. And many people debate all over now that one of the finest appointments made by His Excellency the President.
Well, I mean,
he's got a wealth of experience, his international exposure. He has the knack to actually succeed. He can meander his way through, international corridors and bringing in the very goodies that this government is pretty much expecting.
Well, that is precisely the point I made. I mean, I do not know him personally, but what I do know from the little that I've heard about him, that he is a good negotiator. And in foreign affairs, you need somebody who's going to be able to negotiate on behalf of Sierra Leone, somebody who's going to put Sierra Leone's case forward, because that person is the face of Sierra Leone. And from what I know about him, even though I do not know him personally, I think it's a good appointment. If we have somebody that can project the image of Sierra Leone and that can speak good of Sierra Leone and get others to see the good in Sierra Leone, then we are onto a win-win situation.
Leonardo Pratt has been head of the Department for Peace and Conflict Studies from a college. She headed that department for quite a while now. She has made strides by way of pushing forward that department pretty much noticeably and taking up an appointment. She has been engaging in some consultancy ever since. Her appointment at the Tourism Ministry, and it is one ministry, though there has been some key achievements over the years, I must say, but it is underutilized. This is the aggregate opinion of many people now. Her appointment in that ministry perhaps could serve as a leverage in ensuring that where the then Minister of Tourism, Celia Atuni, stops, she will take the stride in furtherance in ensuring that we meet up with the current challenge.
Well, again,
let's look at Gambia, what is happening in Gambia.
Well, absolutely. And again, this is the point that I want to make, Rahman, that the concept of energizing is an important concept. We have situations where ministries have been moribund for a long time. We see, even in football, teams that have been moribund for a little while, when they have a new coach, that team starts to play in a different way that nobody ever thought they could play like. And again, it's the same situation. Somebody like that who has clearly got a track record in achievement is the kind of person that you would want to put into a ministry that is pretty much on its knees. A ministry that needs a lot of energizing to get it to its full potential. Now, I remember back in the day when I was going to school in this country, the tourism, we had a hefty and a booming tourist industry in this country. I remember the AJ Yazbek buses full of tourists along the beach. We used to see them at Chaka Stevens Street when we come from school. We had a vibrant tourist industry. And again, tourism is one of those departments that can be a good earner for this country. At present, we have a big issue with exchange rates. If we have loads of tourists coming into this country, the exchange rate on its own would drop. So it's important, and this is something that we don't need to invest too much in to get adequate returns. So it's something that we should be focusing on, and I'm glad to see somebody like this with a track record of achievement going into such a department, and I certainly wish her well.
Let me take you to your own jurisdiction, the Justice Department, the appointment of the Attorney General and Minister of Justice in the person of Francis Charles Magai. The impression?
Well, I mean, Mr. Magai is somebody that I've worked with for a while. Whilst I was a magistrate, he has appeared before me on a number of occasions, and I'm proud to say that my court was one of the few, if not the only magistrate court that he would appear in, as senior as he is. Because many a senior practitioner do not appear in the magistrate court. They appear only in the high court. But my court was one of the courts that he used to appear in. And I can only deduce that to the fact that he felt he could practice properly in my court. So far, he is coming as Attorney General and Minister of Justice. I have no doubt in my mind that he would succeed for the simple reason that he has the drive, he has the determination, the knowledge, and at the same time he has the experience to be able to do his job effectively. And with that, I mean, there cannot be any substitute. So from my point of view, I'm happy to see him as Attorney General, and I'm pretty sure that his impact will be felt quite soon.
Adrian Fisher, what is pretty much distinct when it comes to understanding the principal role of Attorney General and that of Minister of Justice?
Well, in Sierra Leone, our constitution provides for an Attorney General and Minister of Justice. Generally speaking, the Attorney General is the principal legal advisor to the government. So, in other words, all government departments, their lawyer is the Attorney General. The Ministry of Justice is a department that effectively is responsible for justice formulation. In other words, the policy in as far as what issues should justice be looking at, issues of justice should we be looking at as a country. The Ministry of Justice is responsible for that. And by virtue of our constitutional provisions, the Attorney General and Minister of Justice wears both hats. So effectively, he is in charge of the Justice Ministry that promotes justice, and at the same time, he gives principal advice to government. And it's for that reason why it's not just him alone, it's got law officers that work with him in what we'll call the Law Officers Department. So in a nutshell, he carries both functions, and that is his task as per the Constitution.
I take you back to a discussion I had a couple of months back with one of your colleagues, Lason Kitakonte, on the need for the review of the Constitution, 1991 Constitution. In his words, he said, the 1991 Constitution is a very good document, but it ought to have been better. Meaning, in as much as it is the only book that we have as the secret document that guides the business of governance in the states, but there are lacunas within that particular constitution that us as a nation will require the right attention to sit and amend certain things within the constitution. This takes me back to what ensued in Parliament a couple of days back, when the newly elected members of Parliament were about to take the oath of office. Of course, you and I know what really happened, and the rest is history. But prior to that, there was this battle for supremacy between the Clerk of Parliament and the outgoing Speaker of Parliament. And it leaves the lay public with so many questions when it comes to the dispensation of parliamentary procedures, be it the political sects or the administrative sects. Who is actually responsible for which?
Well, I think the first thing that viewers need to understand about Parliament, and again, this is something, you see, there's no substitute for understanding how our institutions work. Now, much of this confusion that we hear about and see being discussed in social media, opinions being preferred, this confusion is created by those who have not bothered to take their time and understand how these institutions work. Now, for example, let me just start from here. We have people who do not even know that the president is a member of parliament. I mean, people sit there and scream and shout about, oh, we have separation of powers, blah, 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 blah. But the president, by the constitution, is a member of parliament. Because if you look at section 73 of the constitution, it tells you that parliament is made up of the president, the speaker, and members of parliament. So that's the starting point. The speaker is provided for in the constitution. The clerk is provided for in the constitution. Section 79 and 82 provide for the positions of the clerk and the speaker. They all have their roles. The clerk, let me start off with the clerk. The clerk is a unique position whose job is to be responsible for the administration of parliament. If you like, the clerk is the permanent secretary of parliament. He is responsible for everything that goes on around parliament. He is also an advisor to the speaker. The speaker, on the other hand, is in charge, is the head, if you like, of parliament. His job is to provide over sittings of parliament. That is what he does. So they have distinct roles, but the key issue here is this. When you have certain events like the opening of parliament or the first day after parliament seats and all the rest of it, yes, the speaker is there, the outgoing speaker is there, but the moment parliament meets, he needs to vacate that seat. And then the clerk is then responsible for bringing on board those members of parliament, conducting the election of speaker, after which the clerk then goes back to his own traditional role, which is to administer what goes on in parliament. And the speaker then presides over sittings of parliament. So they have similar, in some ways, and interlinked roles, but distinct roles. And again, people need to understand that.
Distinct but interrelated.
Yes, interrelated, indeed, absolutely, but distinct. But insofar as the first day of parliament is concerned, if you like, the clerk is the acting speaker of parliament until the new speaker is appointed, or elected, I should say. And once he is elected, then the clerk goes back to his own role. So these are all provided for in the Constitution. And I think those who are out peddling all this misinformation need to just take their time and just read through the Constitution.
And I dare say to you that a good number of those that seem to be telling what to do and what not to do, a good number of them are lawyers. And if they are lawyers, we expect so much from them to really enlighten the lay public as to what you're doing currently here, to tell the different roles and responsibility of the two individuals in terms of their functional delivery. And this, to a larger extent, has created a kind of encumbrance. To an extent, people tend to question the sincerity of some of the lawyers as to whether it's a deliberate attempt for them to actually throw spanners in a very good work. The stipulated sections in the Constitution, it depends on who you talk to. They keep referring Section A, Section B, Section X, Section Z. It doesn't tally with what you're saying. Others will come out with an opinion piece and say, no, challenging. There has been that battle of wits among themselves. And for want of word, the conspicuous split among lawyers, tagging themselves as party lawyers, are not helping their party supporters to a larger extent in all of this. It's pretty much scary now. Until we reach a time when they will come to the better realization that it is not about them, but it's about the people of this country. If you are a lawyer, responsibility is to educate the lay public on issues that surround interpretation of the Constitution, not to allow a kind of expansive argument to go on without any better light for people to actually understand. What's your take on that?
Well, I think, Rahman, this is a difficult one, and I need to be clear what I say. Okay? I think those who know me for not being afraid to speak, and speak will I. One of the things that lawyers ought to remember is that being a lawyer does not just simply mean you wear a coat and try and go to court, or you hold yourself out as a member of the legal profession. It's about ethics. And one of the key considerations of ethics is the issue of conflict of interest. You are not supposed to be in a position where you allow yourself to be in conflict of interest. And this is why one of the things that you see, whenever you invite me to this program, Abdul, I am very, very careful in what I say. And the reason for that is this, that as a member of the Bar of England and Wales, they are very, very hot on issues of conflict of interest. I cannot sit here and deliberately interpret the law to suit a position that I want, because if that comes to the attention of the bar in England, I could find myself into problems. So the same thing ought to apply here. If you are in a position where you're supporting a particular opinion, for reasons best known to yourself, it's best not to speak. Because when you do speak and you try and interpret the provision of law to suit the position that you want to be in, then you are acting unethically and you are in conflict. So this is where I always say that lawyers need to be very careful what they say and how they interpret the law. Your interpretation of the law should be supported by clear principles of law. It's not because I want to support this particular party, so therefore I should interpret the law in favor of that party. It's wrong. And again, some of our colleagues do not do us any favors. Notwithstanding that, I should point out as well that there's a fundamental lack of understanding about the law. I can sit here and interpret the law in more than one way. And that is something that our system of law allows. And this is what judges have to deal with every day. Because when you get into a court of law, a judge has to listen to one side that has a particular position on the law, and then he listens to the other side that has a different position on the law. That is perfectly acceptable. The judge then has to decide which position he prefers. So yes, it is acceptable to have lawyers have different positions on the law. But in situations where the law is so clear, and you see a lawyer going out of their way extraneously to take that position that is so clear in law to make it look like, well, in fact, that is not the actual position of law, that is what I have a problem with. But in a situation where there is ambiguity in the law, that is what lawyers do. You would come with your position on it, I'll come with my position on it, and I will leave it for the courts to decide which is the position that they prefer. So there's a fine line between having disagreements insofar as the interpretation of law is concerned, as opposed to deliberately straining the arguments to suit what you want to hear, or suit the position of a group that you belong to, or a political party that you belong to, because you feel that is in your interest to so explain it. That is where I draw the line. That is where I believe that some of our colleagues can act unethically.
We've seen many instances where there has been this onward confrontation among themselves. But the expectation of the lay public is to have seen a position where the civil bar associations would come out quite handy in terms of those complexities. For instance, we've seen the issue about the Speaker of Parliament and that of the Clerk of Parliament. Many lawyers could come taking their position to say what they believe and perhaps could suit them best. I was thinking that collectively, if the body of lawyers, the civil bar associations, would come out and take a position, a neutral position, it will mitigate or reduce the propensity for onward argumentation into all of these. Do I sound pretty much realistic?
Well, you sound optimistic. As to whether you're realistic or not, that's another issue. But you're optimistic. And I'm optimistic as well that ought to be the position of the bar. Yes.
Why, in most cases, have failed to actually come with a singular position when all of these things keep cropping up? They will delay, they will hold back, not to come to the fore and allow the argumentation to go on, and at the end of the day, the lay public start to be confused.
Only they know. What I can say to you is...
You are a member of the Bar Association?
Not of the Sierra Leone Bar Association, no. I'm a member of the Bar Association of England and Wales. And I have to say that we do things slightly differently. When we take a position, it is the position of the bar. Quite recently, about a couple of years ago, when the Conservative government came into office in England, they sought to reduce the fees of lawyers. And with one accord, the entire bar stood up and challenged the government on it. And in fact, we got to the point where lawyers actually stopped going to court in protest in front of the law courts to ensure that the government did not refuse the fees. And again, the government had to have another look at the fees. So that is what bar associations ought to do. A unified position for everybody. Not one set having a different view, another set having a different view. We should respect our association enough that where we have taken a position, because at the end of the day, the bar association has got an executive. The executive should consult, listen to its members, and then take a position or vote on a position on a particular issue. And once the association has taken that position, it should be the position of the entire bar. There should be no dissent, so to speak. And in our situation, like I said to you a couple of years ago, there was no dissent. The bar took a position on that very, very, very clearly. Even insofar as human rights issues are concerned, the bar again takes a position on it, and it's a very strong pressure group on the government. And most significantly, in many instances where the government does things that the bar association disagrees with, we have the bar pro bono unit that will take the government to court. So there are many instances where the government has been taken to court and where out-of-court settlements have been reached, where government have decided to amend the law or not put in a particular provision of law that they wanted to put in that created problems in the first place. So the bar can be an effective pressure group if people can get their act together and say, okay, this is the position of the bar and that is the way we're going to do it, based upon the law, not based upon our own narrow considerations.
So the bar association all by itself is supposed to be pretty much powerful?
Yes. Yes, because the bar association can at any time say, right, today we're going to take the government to court. Because it's a body of lawyers. If they all get together and come to a position and file papers in the court, the government has to sit out. Yeah.
Issues like the dual nationality, issues on constitutional interpretation, and also of recent, the petition that were taken to the court where the Sierra Leone People's Party, the ruling party, petitions on few APC members of parliament, and in turn the opposition, All People's Congress, did the same thing. And what came to play was this: while cases on the side of the SLPP were heard, on the APC side it thought pretty much deprived, that they were not given a timely hearing. All of those cases are filed up country, like in Bo, Kenema. Excuses were given. Could be the judges out there, the magistrate could tell you, well, I will not sit in courts, I'm not feeling through. So many excuses. I will not challenge a reason for any magistrate or judge not to adjudicate upon any matter. I will not venture to do that. But on the bigger scheme of things, it will appear as if it's a conscious effort on them to actually deprive one side. And I wasn't surprised at all when the outcome of the ECOWAS delegation, and also led by the Undersecretary of the United Nations, Dr. Ibn Chambers, urging the judiciary to be fair, independent, and ensure speedy adjudication of matters, especially the petition cases. What the future holds for a judiciary that seems to be pretty much sluggish, the expectation for them to actually adjudicate on matters, rather than we allow the international community to come in and say, you ought to have done this in the first place?
Well, I think to start off with, I think ECOWAS has no business telling our judiciary to speedily deal with cases before them. The judiciary is independent. I mean, I've never seen a situation where ECOWAS has told the ECOWAS Court of Justice to speedily determine matters before it. You know, and I mean, sometimes we need to be firm with some of these issues. You know, courts across the world are meant to be independent, and you cannot interfere into the work of the court. Because, look, one thing we need to remember, Rahman, is that courts have got procedures. You cannot just sit in an office and pull out a press release and say, well, the court should speedily determine this case. We have procedures in the law. For example, when you file a claim against somebody or whosoever it is, you have a number of days to which to serve that other person. So that alone in itself, it gives you 2 clear days to serve the other person before that other person can file a defense. In some instances, when that person has received that document, they have within 7 days to consider their defense to what you have filed. So that alone is 9 days. So there are procedural rules through which the courts work. And the courts do not work on the basis of somebody from ECOWAS or somebody standing in a corner and say, oh, please hurry up and deal with these cases. No, the courts do not work that way.
I honestly don't want to make any misleading citation. Let me just reference a portion of the press release where it was clearly stated, encouraging.
Well, they do not need to encourage the courts.
Okay, let me read it aloud. The delegation strongly urged political leadership to desist from any action that could undermine state institution, democratic governance, social cohesion, national unity, peace and stability. Similarly, the delegation encourages the judiciary to ensure prompt, fair, independent and timely adjudication of all grievances and pending petition regarding the recently concluded electoral process.
Well, that is wrong. And I say it again, it's wrong. I mean, has ECOWAS ever in their history told the ECOWAS Court of Justice to hurry up with cases? I mean, how long does it take on average for the ECOWAS Court to deal with cases? Has ECOWAS ever told them to hurry up with those cases? No, they haven't. And besides, we need to recognize that Sierra Leone...
Are you actually refusing to see the stance of ECOWAS from the point of building unity and peace?
No. It's not a question of stance, Abdul. The issue here is a fundamental principle of policy. Right? Look, the rules, first of all, the election petition rules are clear. It makes for speedy resolution of election petitions. So the rules are already there. So the courts do not need to be told to speedily conclude those election petitions because they have timetables. They have rules that are already in place that make the quick expedition of those matters possible. As to the independence, there are rules. The judges would look at what is before them, and if they conclude on one side or the other, then so be it. If you're not satisfied, you can go to the Court of Appeal. And again, once you appeal, this matter will come up in the Court of Appeal quite quickly. So we already have rules. But we cannot have a situation where courts are being dictated to or are being encouraged or urged to speedily consider matters. Because when you do that, one or the other side might suffer from an injustice. This is why we have rules. So
even in a situation where maybe, and just maybe, the laws of the judiciary or the courts might have been spotlighted?
Well, again, it is all a question of perception. I mean, many of, people need to take their time and read some of these election petition judgments. I mean, we had 2005, we had Magai versus Beira in the Supreme Court. Right? 2012, we had the case filed by the SLPP against the APC. It took the court about 3 months to deal with that case. We did not hear ECOWAS urging them to hurry up and finish this case. The courts should be left alone to do their jobs, and that is my position. They should be left alone. We have established rules of procedures. We have acts of parliament. We have other procedures as well that allows the court to deal with these matters expeditiously. And the judges themselves go all out to deal with these matters expeditiously. I mean, we've seen quite recently the Supreme Court when the case against Dr. Yumkela was filed. We saw judges of the Supreme Court being speedily empaneled. They were sitting in that court until 5, 6 o'clock in the evening. We saw in the cocaine case a few years back, Justice Bramak, now Justice of the Supreme Court, sat in court till 8 p.m. at night. We've seen that. So we don't need anybody telling our judges how to work or how speedily they should conclude.
Could it be a situation of overstepping the mandate?
Well, it is. Because the first and foremost, the ECOWAS principle has at its apex the recognition of the sovereignty of Sierra Leone. And the sovereignty of Sierra Leone means that we have an independent judiciary who is not subject to the control or direction of any other person.
Will you imagine somebody seated in his corner and say, hey, give me a break. All that ECOWAS is doing is in the interest of nation building?
Well, let them deal with that insofar as the political parties are concerned. That's within their mandate. They can urge political leaders to get together. I have no issue with that.
Does encouragement tantamount to coercion?
Well, it's whichever nomenclature you want to use on it, it is interference. Plain and simple. If you are calling upon the judiciary, either coaxing them or encouraging them or otherwise, you're interfering into their work. And we should not tolerate that.
When will you realize a situation that the court is not doing its job?
Well, look, the fact is, Abdul, there are procedures. If the court is not doing its job, you have appeals process. There are appellate provisions. One of the things that you can say is, well, this court took too long. For example, look, we have in our own jurisdiction, the Constitution requires that all judgments must be delivered within 3 months after the close of pleadings. In other words, once the case is complete, you have up to 3 months to deliver your judgment, because some of these issues that are determined on a daily basis by our judges are complex issues. They are issues that require a proper application of the arguments that have been put forward by counsel. So it's not something that you could, it's not like going to the shop next door to go and buy bread. You have to sit down and look at arguments properly, look at previous authorities, in some instances read some of those authorities, and then have a clear position on what the law is. So it is not as simple as simply just sitting there and say, well, I'm just going to go and get bread. Once I pay my 2,000 leones, I get given a packet of bread. No. So this is why, and besides, look, when you have a situation where judges are rushed to give decisions, they're human like all of us. They can make a mistake. And if they make a mistake, what will happen? The other side that is aggrieved by that decision will then appeal, which means the decision becomes even lengthier. Because then once he appeals, he then has 21 days to appeal, and once he appeals, the other side has to respond as well. Then the Court of Appeal has to come and sit on that case again, which means another 3 months. So what do we want? Do we want a speedy resolution of these matters, but then with the possibility that the judges might make a mistake and then there's an appeal? Or do we want the judge to carefully take his time, understand the issues properly, and then give a determined ruling that would bring an end to the case at that point? But as for the interference by somebody or otherwise saying, well, the courts are encouraged to get this matter dealt with quickly, no, that's wrong. That is wrong. And as a lawyer, I would voice it out that it is wrong. They can say whatever they want to say about politics.
As a country, we sign up to specific commitments that allow the ECOWAS to slightly interfere into our governance structures.
No, but not to interfere into our independence of the judiciary. The independence of the judiciary all across the world is sacrosanct. Now, when we had Brexit, let me give you another example. When we had Brexit in the UK, the British government was of the view that those who are filing claims against the government to the Supreme Court would delay the Brexit timetable. The courts did not listen to them. The court took their time to give a decision on the matter. And that is the way courts operate. They are not subject to anybody telling them how quickly to get a matter dealt with, or how they should rush up and determine a case, or encourage them, or coax them up into some kind of a situation where they should deliver these matters pretty quickly. No. They're not subject to anybody's control, and they should be left alone. And that is a position that I hold and will continue to hold.
Conclusively, Hedrain Fisher, given the deep-seated constitutional interpretation that has confronted us as a nation, let's tie this discussion. We don't seem to be having much time left on the need for the review of the Constitution. Taking it from the aspect of the dual nationality, taking it from this question of speaker and all the rest of it, and on to the point where people challenge the proclamation made by no less a person, His Excellency President Julius Malema, recalling the Parliament to commence and do parliamentary business. That in itself, it throws a lot of challenge. Do you see the urgent need for the Constitution, 1991 Constitution, to be reviewed?
Well, let me just deal briefly with the point you raised about the proclamation of the President. Again, those who are raising those points, have they read the Constitution in the first place? And I'll just read for you briefly what it says. Section 84. Each session in Parliament shall be held at such place within Sierra Leone and shall commence at such time as the President may be by proclamation appoint. So it's there, Section 84. That's the President that makes that proclamation for a session of Parliament to commence. So what is the problem with that?
You have a set of laws that will tell you President Bio did not have the right to even have done that.
Well, it's in the Constitution. And if it is, he has a right to do so. On the question of the constitutional review, I am one person that put in submissions to the review committee, some of which were accepted. Now, my position is this: looking at the 1991 Constitution as it is, it needs to be repealed and replaced with a simplified document that will effectively do away with all these issues that we are. I mean, this is one of the longest constitutions I've seen. You look at the US Constitution, for example, it's a very small document. And it's only benefited from about 12 or so amendments since the 1700s. So why do we need to have a document that just gives us more and more and more complications? Because the Constitution should only be the bolt and nut of our country. Bolt and nut of our Parliament can make other laws, but we just need to focus on the key provisions that would inform that Constitution. And I would sincerely hope that this government would take another look at the constitutional review process with a view towards getting a new constitution that we all can be proud of.
On that note, I want to thank you so much for sparing your time being part of this program today, Hedrain Fisher.
Thank you very much.
This is how I bring out the curtain into this edition of the program Familiarize with the Law with my guest, Lawyer Hedrain Fisher, having a presenter. My name is Abdul Rahman Kamara. Have a wonderful